Good evening, everybody. This is an initiative of Soroptimus International Coimbatore. We are planning to have a series of discussions on which are totally women-centric. As young girls and women, it is good to be aware of your rights. The topic for today is going to be women's rights, and our moderator will be our team member, Sujata. Over to you, Sujata.
A very good evening to one and all. Firstly, I think women's rights are human rights, and I think the whole purpose of women's rights is also for fair treatment and also equal opportunities, which I think has been denied over a period of time, and even now in probably in different socioeconomic sectors. And maybe few of us are very privileged that we have equal opportunities and fair treatment, and we are in the position where we can voice out in case something is going wrong. So that's the reason I think this topic is very important. And women's rights is not only about women, it's also about men, and it's about coexisting in peace. So that is setting the context for the day. And without further ado, I would like to introduce the guests for the day. We have Ms.V.Mohana ma'am, who is the senior advocate from Supreme Court. Welcome, ma'am. We have Udaya Menon ma'am, who is also the advocate from High Court and Supreme Court. Welcome, ma'am. We have Ms.Udaya Mohan ma'am, very good friend of all of us, and she is the advocate from Coimbatore District Court. So without much further ado, I would invite them to talk on this very, very important topic of the day, women's right, a panel discussion on women's right by these eminent panelists. Welcome, ma'am.
Good evening, Ms. Sureka, and good evening, Ms. Sujata, and all other participants. It's a pleasure to be here in the Coimbatore panel, where I belong to Coimbatore, and it's a pleasure for me to talk to you all. Though it may not be only restricted to Coimbatore people, I'm just let me just thank for this opportunity. And without much waiting, like Sujata has rightly put, women's rights is fundamental, and it's not only about women but also about men, and treating and getting an equal treatment and in an equal platform. See, in fact, our constitution, the preamble itself envisages a socialist and equality and equal protection for all in the country. So for equal treatment, there is an Article 14 in the Constitution. The Constitution of India is the document which actually gives a framework for governance of the country, and it gives out what are the rights, what are the duties of a citizen, how a country has to be governed, how the states will have to take protection, give protection to the citizens. In fact, in the Constitution itself, actually the women's rights are envisaged, and an extra protection for the women, because the Constitution has come in 1950, and at that point of time, of course, women were nowhere to be seen in the general area, and they were to be brought up socially, economically, politically, educationally, they were to be brought forward. So therefore, salient features are there in our Constitution. So I will just, one day's time is not enough to in fact, explain all of you about what are all there, but I must give you an overview of what are our rights. In fact, we have an Article 14, which prescribes an equal protection of laws and equality before law. While saying that, in fact, we have an Article 15, which says equally everybody will have to be treated, but there is an exception, because constitutionally, there has to be an extra protection and a special reservation envisaged for women and the socially and educationally backward people. In fact, for women, 15.3 contemplates there are special legislations to be given. That is how we have horizontal reservation for women in all these spheres. In public employment, the meaning of a horizontal reservation is that a vertical reservation is actually based on caste, religion, like you have MBC, OBC, etc., etc. Whereas in an horizontal, it cuts across the categories, irrespective of caste, creed, class, everything, because women, there has to be a reservation even in general category as far as women are concerned. That's what is envisaged in 15. Article 16 also. We have very type of cases, in fact, decided by the Supreme Court and High Courts time and again to reiterate and emphasize this aspect. we have our fundamental rights from Article 14 onwards. That is various rights that have been given to us, and especially women, though it says equality, even all the fundamental rights and the fundamental duties envisage that women will have to be treated with respect and dignity, and there should be no discrimination when it comes to their workplace or in their personal life. That is how we have a series of legislations framed by the center as well as the states. We have some property rights. In all religions, we have property rights, especially, in fact, very, very recent. In fact, till 1937 in Hindus custom, they never used to hold properties. They didn't have right to hold a property also. In 1937, there was a legislation by which they were able to hold properties, possess properties. That was also a limited right. But in 56, what happened was there was a drastic change and they were given absolute right to hold their property. Even there was a restriction as far as the co-partnership or joint family properties were concerned. They were only held by men. Only the father's one share was divided among the other children along with the sons. So now in 2005, there has been a very drastic change brought about by legislation so that women can hold equal share in the co-partnership property also as far as Hindus are concerned. We have similar rights for Christians and for Muslims in the respective religious enactments and everything. We have matrimonial rights, and in that we have right for restitution of conjugal rights. We have right to get maintenance while being married and even after marriage, even when a divorce proceeding is going on, and thereafter also, as long as you are not being maintained. There are various enactments. In fact, a CRPC, that is Criminal Procedure Code, is common for all the religions as far as maintenance is concerned. These are all actually envisaged in the Constitution, in the directive principles of state policy, though they are not actually justiciable, or you cannot go to a court to enforce a directive principle of state policy, which is only a principle envisaged. Still, the court has now taken it forward and then said even these have to be, if they are not emphasized and brought forth by the state and the mechanism, it is very difficult to bring women's rights forward. See, if you take as far as the divorce laws are concerned, now we have extra protection. In fact, some matrimonial laws, for example, Hindu Marriage Act and all, they give one jurisdictional aspect, a benefit to the woman to file a case where she is located. Whereas normally cases are filed where partially the cause of action has arisen for a case or where the respondent or the husband resides. Whereas for a Hindu woman, there is a special provision that she can file a case where she is residing. In fact, there is a provision in the CPC to transfer a case from one state to the state where the lady is staying if a husband files a case elsewhere. Likewise, we have protection of human rights, and we are all actually, India is a signatory to various United Nations conventions like CEDAW, Convention on Elimination of All Forms of Discrimination Against Women. In 1993, we are a signatory, and from there onwards, we have taken it upon ourselves to whatever domestic law we are now forming. We have to keep in mind that we are signatory to various conventions, international conventions also, which is why we have our DV Act, Protection of Women Against Domestic Violence, for whatever violence that happens at the domestic front. We have in workplace dignity has to be maintained is also envisaged in the Constitution. So therefore we have sexual harassment that is now prohibited under an enactment, POSH Act, which I think one of my friends here will take you into more details about that legislation. Domestic Violence Act also, Udaya Menon may be able to take you through the whole thing because she's in that area of practice as well, among other subjects. And we have legislation such as, there are certain states which have given protection for women by prescribing equal remuneration. As far as there is an enactment called Equal Remuneration Act, which prescribes men and women have to be equally given their salary when it comes to any employment, especially public employment. So these are about our fundamental rights, directive principles of state policy, and all of them are the pillars and the preamble. They are the pillars of our Constitution, which has given us a direction to take our legislations forward so as we get adequate protection and our rights are enforced in particular. Now I will give you some certain examples of how they have actually enforced. Maybe not to bore you much, I'm just deviating a little bit. There are circumstances where in a case where Punjab Excise Act, there was a provision where you cannot engage boys less than 25, men less than 25 years and no women at all can be engaged in hotels for supplying alcohol where there is a boarding, lodging, and also restaurants and bars located. This was challenged, saying it's a pre-constitutional law, which is in fact in an evolving socio-economic change which is happening in the country. These certain provisions which are prohibitive and discriminatory in nature cannot be withstood. The High Court quashed that provision. The argument of the state was, it is a protective legislation, and secondly, we can't allow girls to work in hotels because we can't give protection to the girls when they are working in such atmosphere where alcohol is served. It was deprecated. Such an argument was dispelled, and the Supreme Court also affirmed the judgment of the High Court, saying, if people, boys and girls together, go to study catering technology, today times have changed. There are social developments. Educationally, people are forward, and everybody is treated equally. When women are also studying the particular hospitality management and hotel management, they cannot be prevented from going for an employment. It is completely prohibitive and discriminatory. And state cannot shy away from their protection, from their duty of giving protection to the women. And on that ground, you can't ask that women cannot be permitted to serve alcohol. So that was, in fact, quashed, the provision. In fact, in Maharashtra, what happened was cine artists were there, and there was a trade union which actually prohibited women from becoming a member because they can only act as hairstylists. They cannot become makeup women. Only men can be enrolled as makeup artists. The women they were depriving the women of even taking the membership in a trade union. So therefore, that was brought up by a person, and then Supreme Court decided that among them, trade unions, in fact, they are all registered. They are almost like a state organizations. They cannot discriminate between a woman and a man as far as makeup artists are concerned. They are all very well equipped. You can deny opportunity if you are not qualified. If a person is qualified, just because a gender of woman is there, you cannot just prevent somebody from acting as a makeup artist. So these are certain judgments, I'm saying, for example, to perpetuate and to implement. This is, judiciary is one wing of the constitution, of the governance, and the constitution envisages that these are the protection that is given has to be perpetuated and implemented only by this. Legislations will give enactments, but the courts will have to give effect when people approach the court for any remedy. We have also rights such as property laws. Apart from that, criminal law rights also. In IPC also, there are various amendments that have come into picture, serious. And when I'm filing a complaint for any offense that has taken place, all that, how to file a complaint, there are mechanisms which has been made easy. So women will have to be first aware of their rights. That's most important. Like I know Ms. Sureka said in the beginning, first, unless you make them aware of their rights, it's very difficult. In fact, as far as the political rights are concerned, the Constitution has given one reservation for women in municipalities and panchayats. It's mandatory for every time 1/3 of these municipalities and the panchayats will have to, even for a chairperson post, they will have to be reserved for women. So irrespective of women contesting in other posts in general with others, these are certain mandatory provisions that they will have to implement. The state mechanisms will have to implement that. So what I'm trying to say here is that though the Constitution has given us a lot of provisions for women, and they will have, and after all this, and after all the legislations, and after all that has come up so far, we have reached a particular stage. But if we have reached that level where we can fully say that we are equal to men in all aspects, that's a question, that's a moot question that will have to be discussed, and we'll have to see how far we have come. But one thing is very clear, apart from the state coming into the foray of giving advertisements, giving some notifications, media publicity and everything about rights of women, it's not only in paper that they should give all these legislations. They should be made aware of their rights. Secondly, that organizations such as the Soroptimist and others who are taking up these women's rights and propagating this, and then conducting programs like this also help, and they go in a long way in educating these people, young women. And and in employment also, please understand, there are Maternity Benefit Act. I must tell you, I know due to the time being very, very short, I'm just cutting short everything. Maternity Benefit Act is there, and medical termination of pregnancy is also there. Depending upon the safety of the person, there is a permission for that. And a woman's right to reproduction and abolish female feticide. There are legislations to protect whether a fetus cannot be located, cannot be detected in any sonography test because it's punishable under law. So therefore, I must tell all the women present here, these are all legislations which are available to us. And if we are aware, if the people who are here, if they can make the other friends aware also, that will also take us to a long way. So with this, I will invite Udaya to take us forward to the next part of this actually. Thank you.
Thanks a lot, Mona. Really, it's a very pleasure to hear your special guidance also. And first of all, I want to thank the organizers to give this very good opportunity. And good evening, everybody. Just I want to put my suggestions regarding the Protection of Women from Domestic Violence Act. This act was brought to protect the women from domestic violence. Now, especially at the time of COVID pandemic, domestic violence and abuse against women increased now very much, and domestic violence victims in the home is most unsafe during this quarantine period. So under this act, all women, including either wife or mother or sister, all women in the family can seek protection under this act. And I can give only, as Mohana ma'am says, I can give only an overview of this act within 10 minutes because we have to explain a lot under this act. First of all, I want to tell this is a single window act to empower women. First time it was introduced because for custody, they have to go for a family court, or if they want a protection, they have to go to the magistrate court. Prior to this act, if they want a many monetary aspect, they have to go to the family court or some other magistrate court. So, and first time a special feature was introduced by this act is to get the compensation for the victim, especially it's a civil remedy. It's a civil law, though it is coming under magistrate jurisdiction of the magistrate criminal side. This is a civil law and civil remedy has been given under this act. In this act, section 2A of this act says who is the aggrieved woman, how she can give a complaint, and very important 4 concepts have been explained under this act. Main is who are the respondents, that is who are the opposite parties, who can be the opposite parties, and a person, how she can give a complaint, what and all she has to prove before she can approach the magistrate or protection officer to give a complaint under this act. There are main 4 concepts are there. Main is, one is she has to prove she is the aggrieved person, that is, she is the victim. So if she wants not to prove that she is the victim, she has to prove that the respondents, the opposite parties under the act, and she should be in a domestic relationship with that respondents, and she should be in a shared household, and fourth aspect is she should suffer a domestic violence. So in this act, there are 4 types of relationship have been given as a domestic relationship. One is by blood relationship. Either everybody think it's between the husband and wife, but apart from husband and wife, any type of blood relationship, brother, sister, mother, son, father, daughter, any type of abuse caused to the women, she can approach under this act as a blood relationship. And second relationship by way of marriage or in the nature of marriage. That means even it includes a living relationship, or they lived as husband-wife to the public knowledge. They are also coming under this domestic relationship. And third one is relationship by adoption. And fourth one is living in a joint family relationship. If in one of my case, the husband died, the daughter-in-law suffered and she has undergone abuse with the other in-laws. So the daughter-in-law has filed case against the brother-in-law and has co-sisters. So it is a maintainable because previously she was living in a joint family relationship with her husband. After her husband died, she can file a case against domestic violence. So first thing she has to prove is she is under the domestic relationship under this act. Second one is she has to prove that she is under shared household. There's a very important concept and very broad concept under this act, but it was given very briefly, defined under one Supreme Court decision in S.R. Batra and Tarun Bhadra. In that case, this concept is very briefly defined. They told there are three types, that a shared household maybe belong to the husband, or it is jointly belong to, owned by the husband and wife. And third one is, it may be shared household, may be in joint family. If she lives in a joint family, it is also known as shared household. Or both husband and wife rented out the premises, it is also shared household. So if any of the women, aggrieved women are victim, if she resides or if she lived under this, either in the shared household, as I say, like if it is the absolute ownership or joint family or rental house, she can seek shelter. She can get the protection under this act. And if a woman want to proceed under this act, she has to prove she lived with the respondents in the said shared household. So under section 17, this is a very important remedy given under this act, is residence order. So under section 17, the aggrieved women can given a residence order in a shared household, and if she is unable, shared household means that where the husband lives or where she was in joint family. So in this, the residence order, if she is unable to live in the shared household, she can get the alternative accommodation. She can seek an alternative accommodation, and court has given an alternative accommodation by giving a rental payment. So fourth important concept is respondent. This is a third important concept. It's a respondent means who will become respondent, who can become the respondent. This is also respondents opposite parties, has been defined under this act. Initially, it includes adult male, husband, or relative of the husband, which including the women. So even mother-in-law, you can include, daughter-in-law can include mother-in-law, and any relatives of the husband can be included as a respondent under this act. But in 2016, the Apex Court has removed the word adult male. Now, the aggrieved women can file a case under against husband or relative of husband, which including women also. So even any women who is living under the family, she can be a wife, mother, mother-in-law, daughter-in-law, or any sister, any women can file a case under this Domestic Violence Act. And fourth concept she has to prove is domestic violence has taken place. So she has to prove that agreement that she is suffering from domestic violence when she lived in the domestic relationship in the shared household. So court has clearly given a definition. It has given a broad definition about the domestic violence. Under section 3 has given different types of domestic violence. So it includes physical abuse, mental abuse, or sexual abuse, and it includes the economical abuse, and also the emotional abuse. The person, if the victim or aggrieved women, if he suffered by physically, mentally, sexually, emotionally, or economically, she can prove that she is suffering from domestic violence, and she can get the relief under this act. So many cases, there are no evidence to prove that the domestic violence has been taken place. Even while drafting the domestic violence pleadings, we asked the parties to produce even the police station complaints or any injuries or medical reports, or either the photographs what she got injured. That also will annex along with the pleadings. So there are many, it's a prima facie, we have to prove that domestic violence has taken place. And secondary thing, we have to prove that she is in a domestic relationship with the respondents by way of producing voter list or Aadhaar card, like a gas connection or something else. Because in a case of live-in relationship, in other case, if they live together as a husband, wife or other relationship, they can prove easily. But in a case of live-in relationship or the marriage, in the form of marriage, they live together as husband and wife, we have to prove the shared household by producing documents like Aadhaar card, ration card, gas connection, bank passbook, etc. So that is a very basic point to be proved. And in this act, a very important aspect is it is, as I say, it is a single window act to empower women, and it is a civil law. Recently, in Madras High Court has given a very lengthy decision by Justice Anand Venkatesh. He has very clearly stated that this is a civil law and it is a remedial law. So all type of civil procedure code will apply under this act. That means though the case is filed under the magistrate court, we can apply civil code and we can get the remedies as per the civil remedies. So that law has given 5 type of remedies, like section 18 as it's given a protection order, and section 19 is a residence order. Protection order, any type of a victim is suffering from some abuse, she can be protected under this act. And section 19 is a residence order. If she has driven away from the marital home or the shared household, she can seek a shelter under the same house. She can even prevent her husband or the respondent not to disturb her where the portion of the shared household, or she can get an alternative accommodation by the given that alternate accommodation from the respondents. For that, rent has to be paid has to be bared by the respondents. And section 20 is the monetary reliefs, like maintenance. How under family code they are going under section 125. Same procedure will be adopted here, and monetary reliefs like maintenance and monetary reliefs for the food and shelter has been given under section 20. And section 21 is the custody order. This is if they got a child, he cannot be removed from the mother, or she can tell the custody of the child can be decided, can be given under this act. And very important one is section 22 is the compensation order. This compensation has not been given under any of the act. This is easy access to the justice, easy proceedings in the court. So aggrieved women can approach either directly to the protection officer, or she can file a case under the magistrate, or on her behalf, some person can appear, or if she is very badly injured or she is unable to approach the court or magistrate or protection officer, even the medical home or some shelter home can file a case on her behalf. So this is a very important act, and there are a lot of aspects to be explained under this act. And recent judgment, Madras High Court has given very important directions to the Family Violence Act, and clearly says that remedies are and reliefs, the agreed different type of reliefs. And main thing is, this is very summary proceedings. That means if a agreed woman has given a complaint, it should be taken on file within 3 days. And that matter has been decided within 60 days. The complaint should be decided on merits within 60 days. So it's a summary proceedings. And very important, another aspect to be mentioned here is regarding the domestic incident report. How we are giving first information, an FIR at the police station. Here we can give a report in a protection officer. It's called DIR, Domestic Incident Report. So protection, if you approach directly to the protection officer, she can examine everything, and she can record in the form, particular form, It's given under the domestic rules, domestic violence rules, Form 1, Form 2, and Form 3. So she has to record what are the incidents happened in a chronological order, and she has to sign the particular form, and she has to send it to the magistrate. If the offences are very grievous in nature, she can send it to the police station, and the protection officer, if the agreed women are victim, if she approaches directly to the magistrate, it is the mandatory for him to send the victim to the protection officer to record the domestic incident report. So this DIR is like a FIR in complaint. It is treated as a very important public document, and on that basis, all cases should be decided within 60 days. So anyway, that 60 days is, though it's a mandatory for the many reasons, this is entire process is delayed because one of the respondent will go for quash, and it will be stayed by the High Court, and there are long delay happened due to many reasons. Even though this type of domestic violence proceedings are very, very important step, that is a very crucial steps at empowering women and under the Single Window Act. So I'll come under, I think it's just an overview I have given. If you want to explain everything, we need another 1 to 2 hours. Thanks a lot for giving this opportunity. And thanks a lot, one and all. Thank you very much.
I think at this point, this is just one more thing for what Udaya Menon has said, and Ambi also going to say about a very important aspect of sexual harassment. That all of us, please remember that we all have free legal aid available for us under a specific enactment, which is actually enacted under the principles of the Constitution. We have free legal aid under the Legal Services Authority Act. So therefore, women are entitled for free legal aid from the district court till the Supreme Court. If you have any problem, there is a legal aid cell. You can approach them without paying anything. All the disputes can be carried forward without, just because we don't have wherewithal, we need not wait. Even if you have wherewithal at that point of time, some women may not be having the wherewithal to go and fight a case. So it's a very important aspect. And thank you, Udaya. Ms.Ambujam can please come out with the other important aspect of women in workplace as well as domestic front, the sexual harassment aspect, which actually is one of the important aspects to be considered by under the women's rights.
Thank you, Mona, for that introduction. And good evening to all the audience. And many thanks to Sujata and Sureka for arranging such a program for us to interact with the audience and keeping them and giving us a chance to giving them the awareness regarding the gender discrimination that's happening in the domestic front and in the working atmosphere. So now I would like to say the bold words of Banwari Devi. The voice I raised against injustice should not be quelled, whether I live or die. This is from a village social activist who was the main reason behind the passing of the Protection of Women Against Sexual Harassment Act. The act is Sexual Harassment at Workplace, Protection, Prevention, Redressal. That act passed in 2013. She is a very simple social worker who was appointed by the Chief Minister to eradicate child marriage in Rajasthan. When in her process, she was put a lot of insult and violence to stop her from doing her this sort of awareness and this sort of social activity. To show their vengeance, few had they were royal family people who were conducting a child marriage. They tried to, they all raped. Did you miss for a long time?
Volume, it's come back. The volume had gone.
Yeah, okay.
That's
it's okay now. The audio is okay now?
And now it's okay.
Okay. So this social activist from a small village, she could bring a big revolution to our country by passing of this particular act. Because before this act was passed, every woman who had gone through the violence in her workplace had to go to the police station, and she has to invoke the section 354 of IPC, that is the assault or committing a crime that outrages her modesty, or she had to invoke IPC 501, which is again her indecent remark or her committing a indecent activity towards a woman. So now this act is the one landmark, act which brought, is my audio okay?
Yeah, your audio is okay.
Okay. Yeah.
I hear you.
This is the act where it provides an in-house committee to find a redressal committee inside the establishment itself, instead of women going to the police station or to the department. So, and this particular act came in 2013 after the Vishaka case. That's where I was talking about Banwari Devi, wherein Justice J.S. Verma, ex-Chief Justice of India, said, see, any violence happening to a woman is depriving of human rights to her. It's her universal right. It's a universal right to work in a safe atmosphere in a very decent manner with dignity. So anything that affects that is right going into the human right itself, denial of human rights. So this is a particular case where the case is known as Vishaka case, and Vishaka guidelines was passed, wherein every establishment, being organized or unorganized, every department, institution, all sort of establishment is supposed to have a complaints committee called internal complaints committee to address the violence happening in women's workspace. Not only that, it placed a lot of responsibility on the employer also, giving him a big responsibility and duty to ensure that women working in their space is safe, that they provide a safe atmosphere and keep it, there should not be any hostile environment in their working space. So much responsibility was given to the employer also. And moreover, the guidelines ensured that every woman working there should know that there is an internal complaints committee existing in their workspace, where her day-to-day, whatever violence committed to her or any sort of sexual harassment can be easily be addressed to the committee already set in her working place. The the guidelines also says how the internal complaints committee or the local complaints committee has to be constituted, and how they have to facilitate the complainant in preparing the complaint, in framing the inquiry and
You're not audible, Mohana. Your volume has gone off.
It's okay now?
Yeah, now it's okay.
Okay. So this Visha, so is it audible?
Yes, now it is.
Yes.
So the Visaka committee has made it compulsory that there should be existent and a constitution of internal complaints committee in the organized establishment and a local complaint committee in an unorganized establishment. So what is the internal complaints committee's duty is, if suppose in a workplace violence happens to a woman or sexual harassment is being imposed on a lady working there, there should be a committee wherein the members of the committee are the presiding officer, which is the senior most lady in that particular establishment, along with 2 members being ladies and 2 members being gents. The minimum is 5 of them, and they have to inquire into her complaint. Not only that, they have to help her in framing the complaint, help her in the process of the inquiry and the redressal of it. And if it is happening in an unorganized place, say a bus stand or a park or a public place, it has to be addressed to a local complaints committee, where there should be a district officer, a special district officer appointed by the collector to inquire into such cases and facilitate the women victim who have gone through this sort of violence or discrimination. So it is the duty of the special officer to help her in doing it. And there should be a local complaints committee wherein there is a chairperson, again 2 members, lady members, 2 members from the male side, and an NGO, a neutral member, an NGO, who will inquire into the such activity. And there are the other procedures, like within how many days the inquiry happens, what is the mode of redressal, the mechanism to be followed. So this Vishaka committee has ensured that every establishment, being organized or unorganized, will have to have a redressal mechanism in their office. And not only that, it is given a much more responsibility to the employer also in keeping these employees, the staff, aware that there is an existence of such an ICC. Not only that, and also it is the responsibility of the employer that before the staffs are being employed, in their standing orders or in their disciplinary that policy, it has to be entered that in case of any sexual harassment happening, this is going to be the penalty, or this is going to be the disciplinary action which will be taken. And it is the responsibility of the employer again to make it public in the conspicuous place in the office, to say that there is the existence of a internal complaints committee, and what would the number to be contacted, who are the members who will be proceeding with the inquiry, all this. And it is also mandatory that they have to see what sort of penalty will be given in case of such violence happening to a woman. So now everybody will want to know what is the what are the activities that are actually sexual in nature. It is not necessary that it has to be a personal or a physical contact alone. It can be a visual sort of sexual harassment, that is sending messages, pictures, or showing some pornographic in the screen to the female colleague. It can be even showing some, sending papers, the official papers with some defamatory, discriminatory, and something in sexual in nature. Even leering, staring at a person and keeping her in a very undelicate and very unsafe environment is also amounts to sexual assault or sexual violence. So for all this, women, like as our advocate Mona said, all the activities, none of the activities should affect or her safe place. Like, she should be kept in a very safe environment where she can work with dignity. So the employer ensuring such a safety environment is his prime duty. And now we came to know the ICC and the LCC, which is existing in the district level within the collectorate's power. It exists there. So what all the women public should know is the existence of the LCC also. When there is a sexual harassment happening in a public place, they can always refer it to the LCC. So this is the procedure, and we should know what is the relief like. If it is happening in an organized sector, the internal complaints committee can pass certain recommendation like transfer of the perpetrator if the woman is feeling unsafe in his presence to conduct her inquiry, or even they can transfer her. She can ask for a transfer or a long leave to keep herself safe till during the inquiry is happening. And the recommendations can be like suspending him or ordering a compensation for the both the mental and the physical injury she has undergone, or if she has lost any of her monetarily or mentally in her career, she can seek compensation for that damages. So all that sort of recommendations can be passed in her favor. And this recommendations of the Internal Complaints Committee has to be passed on to the employer, who has to execute these recommendations as a relief for the victim. And there are a lot of guidelines regarding this also. The victims, the inquiry should be kept very confidential. There should not be victimization. And in the prescribed time, these redressal or the relief has to be passed. And it has to be reported to the concerned department. And it is their, the employer's duty, that employers and the organized sector's administrative duty, that they have to report how many cases are being reported to them, how was the inquiry conducted. The report of the inquiry should be handed over to the, should be reported to the their department or their higher authority. Similarly, in the locals complaint committee also, it has to be 30 days is the time for taking up the matter, and 90 days to be passed, the report to be passed, and the recommendations to be, the verdict to be passed. So this is how it is happening. So every employer has to keep his staff aware that such an ICC committee is existing, and there should be a lot of training and coaching should be conducted within the premises for the employers also, to know how to conduct this formation of the internal complaints committee in their organized establishment. So this sort of continuous awareness program. And there should, our recommendation is that there should be a counselor also appointed in every established place, where a woman can go and speak openly to them, to know that whatever sort of the action or whatever sort of the gesture from her male colleagues amount to sexual harassment, and what is the grievance, whether it should be reported to the internal complaints committee, and what is her immediate action for it. All this should be done through a counseling. So our recommendations is that every office should have a counselor, and say every month or at least a quarterly one-to-one discussion of the staff along with the counselor should be happening, which will protect and prevent such sort of sexual harassment at the workplace. Because this sexual harassment, it really affects the dignity of the woman and her right to work in a very safe atmosphere. So this is what the Act says. And the Internal Complaints Committee and the Local Complaints Committee are the two different organs, always working for the prevention of such a complaint happening to women. So this is how it goes. This is as Udaya Menon spoke about the domestic violence happening in the domestic. There is an officer there also where it can be referred. Similarly, there is a district special officer where anything happening within the district can be referred to, and such a woman can be, she can seek her protection and redressal. So this is how the establishment is in the working place.